Welcome to Tea Times with PEL. This is the U.S.-Asia Partnership for Environmental Law. And we have these monthly, and we welcome some new faces. I think you're new here. Today we have Xiaoyu Zheng, and she is the Assistant Director of the U.S.-Asia Partnerships for Environmental Law and Assistant Director, and she will be speaking about environmental public interest litigation. Just hit resume.
I've already resumed.
Okay.
Hi, everyone. Thank you, Greg, for the introduction. So today I'm going to talk about the development of China's environmental public interest litigation. We call it EPO, as this is quite a new system developed in China. So because a lot of the terms or the system or the legal system is so different from the US. So if you have any questions during my presentation, feel free to raise your hand or to go ahead and ask. Okay, so I'm going to talk about the background and the history, the short history of the EPO development, and then I'm going to talk about one or two typical cases. And then I'm going to introduce the controversies of the EPO system now facing. And finally, a little bit of a comparison of China's EPO versus the US citizen suit. So first, the background and history. So environmental public interest litigation is it's fairly new in China. Because for years, plaintiffs only have been for years, like the environmental related suits are mainly focusing on the tort liabilities. So, and a lot of the time, the plaintiffs has been strictly confined to citizens, corporations, and organizations whose interests are directly related to the lawsuit. Now the EPO that we're talking about is a new type of suit that in China, environmental social organizations or NGOs and procuratorate can bring to the courts on behalf of the public. So there are two types of plaintiffs for EPO cases, basically. So one is the NGOs, and secondly is the procuratorate. So in the latter part, you can see the development or the history of the EPO system construction is been divided into these two phases. The first part is that only the NGO comes into play, and the second part, the procuratorate will come into play. Well, the discussion has been, it takes more than 10 years for China to establish the EPO schemes in law, and of course may take even more years to fine-tune the EPO system through practices. So in March 2005, there were 28 members from Chinese People's Political Consultative Conferences, we call it CPPCC, made a proposal. The proposal is called a Proposal on Promptly Establishing and Improving Environmental Protection Law for Public Interest Litigation. So one of the members one of the 28 members, his name is Liang Congjie. So he actually established, well, he's a very prestigious person in China. Another of his achievements is that he actually established Friends of Nature in 1994 as the first environmental NGO to be officially recognized by Chinese government. So he's also one of the members who made this proposal. In this proposal, it caused the need to establish the public interest litigation system in China so as to protect the welfare, to guarantee the environmental rights of the public. And then it takes years. It takes years, and then, as you know, China has been facing a lot of environmental problems, and all those, the smog and the fog and all these threats has been really like clearly seen by people, and as a heated discussion for environmental protection. So one major step forward to push forward to the public interest litigation systems construction is made in the year 2012. So there's in the year 2012, there's an amendment to the civil procedure law of China. So in this law, it first allowed the agencies or organizations to bring litigations against those who undermine public welfare. Versus in the past, as I mentioned, only the people who are related to the lawsuit whose interests got harmed can bring the lawsuits. So this is a major step forward. And the biggest change happened in the year 2014. In 2014, there's an amendment to the 1979 China's Environmental Protection Law called EPL. This amendment got into effect on January the 1st, 2015. So this new, we call it a new EPL, new Environmental Protection Law. People commented it as the first environmental protection law in China that has teeth, because the old law basically is just a law sitting on the shelves. There's no like very practical value. But for this law, it, among other stricter provisions, there's one big change for this environmental protection law is it affirmed the standing for NGOs to sue environmental public interest litigation cases. So there are two requirements for an NGO to bring an EPO case. The first is that the NGO have to be registered with the government civil affairs department with a, on or above the city's level or the cities with a district's level. And the second one is that such NGO have to be engaged in public service activities, environmental protection for 5 consecutive years without a record of violation of laws. So satisfying these two requirements, the NGOs have the standing to bring lawsuits. This is, well, I'll do the comparison probably later. But worth to mention that for this, it's really a long time, like for this amendment to get passed. It takes a long time because I think it takes 4 rounds of discussion in the National People's Congress with the amendments, and one core discussion point is the standing issue for NGOs. So it's really rarely seen in China to see an amendment to go through 4 rounds of discussion for the amendment to pass. So that's another demonstration of how hard it is to push forward the promulgation of this system. And in China, when the law is there are like the courts started to, or the courts of the people, ever since the effective dates of the new environmental protection law, a lot of our partners in China, the NGOs, starting to test like how this law can be applied in real life. And the courts as well, they are the ones, they don't know how to handle these EPO cases, as this is a really a new type of cases for them as well. So on January the 6th, 2015, so that's about half a year later, the Supreme People's Court of China has released this judicial interpretation on environmental civil public interest litigation. I would cast your attention to the civil part, because later on the procurators will bring the administrative part. But the SPC's judicial interpretation, actually this is very important, for it gives some guidance to courts at different levels on how to handle these cases. And these are kind of like the first judicial interpretation on EPO. Then this is a quote from Justice Zheng Xuelin. He's the director of Environment and Resources Law Tribunal of the Supreme People's Court. So he said, the judicial interpretation on environmental civil public interest litigation, which is a powerful sword, has been made. We hope this sword can cut through the dirty stream and clean the gray smog air. It will be like a sword of Damocles that hangs above the polluters. So as you can see, after issuing the promulgation of the new environmental protection law as well as the judicial interpretation makes people really think like the government is serious about this. The e-pool system is starting to at least to be put into practice. So, and a lot of our partners in China, as I mentioned just now, the NGOs starting to try to bring the e-poll cases and who of course met the two standing requirements. But at that time, the NGOs can bring cases, the civil cases, as well as bring cases against governmental agencies who has been either failed to fulfill their duties in protecting the environment, or they have been involving some non-feasance of not doing their duties. However, as you can imagine, it's always been very difficult for NGOs to challenge the government's actions in China. And also, I think in other countries as well. So now, from after the release of the judicial interpretation by the Supreme People's Court in July 2015, the Supreme People's Procuratorate also launched a 2-year pilot program. For those of you who are not very familiar with Chinese system, so in China, the People's Procuratorate serves mainly as the criminal prosecutors, but they have other responsibilities and duties as well. For example, they at that time they still have the duty to fight against the crime, the anti-corruption or abuse of power, or so that it's very powerful for them to kind of like doing investigation and issue grants for doing investigation of all these criminal cases, as well as investigation on governmental officials for their non-feasance or abuse of power. So this is the background for the People's Procuratorate, and usually they serve as a criminal prosecutor. So in July 2015, the 2-year pilot program launched by the Supreme People's Procuratorate, we call it SPP, was launched in 13 provinces. So in 13 provinces, there were the 13 provincial procuratorate from 2015 until after 2 years until July 2017, they have handled more than 7,000 public interest cases. And among all these cases, they actually filed 934 lawsuits. 222 lawsuits actually went before court, because some of the cases they might have using a pre-trial procedure, or a negotiation mediation, or the government agencies might corrected their act, so that closed. So 222 actually went before court. It's funny to see that all the 222 cases brought by the procuratorate, or we call it a procuratorial procuratorial public interest litigation cases, all win. So the courts rule in favor of the procuratorate all the time, which is understandable, because at that time it seems like this is a pilot project, and all the courts and the People's Procuratorate, although they are different they belong to a different system. However, it seems like they are kind of like in the process of testing and trying to establish the good cases. And so all the more than 200 cases ruled in favor of the SPP. So the following are their achievements for all these cases. They help to restore arable land, forest, grassland, and ordered more than 1,000 companies to rectify their behavior and retrieved state assets as well.
Can I ask about the state assets?
Sure.
Is that in terms of penalties or fines or cleanup costs, or what does that mean?
How to go up to the state assets?
Mm-hmm.
Because for the procuratorial public interest, there's also one aspect for their public interest protection function is to also related to anti-corruption, and so that they like for the SOEs, if they like mismanage the state assets, that's kind of like counted as a state assets loss. So it's not. So it's from that perspective. It's not like restore the. I don't think it's related to the restoration of forest. Correct me if I'm wrong, Dog. That's my understanding.
I think so. Yeah.
Right. It's
So
about
state assets.
Yeah.
So it's like land or like.
No, like for example, if an SOE has even like their companies, their running of businesses, all this money are considered state assets. Even so, if they, for example, help the SOE to avoid a loss of a certain amount of money, they count it as a save of state assets. It's not from the perspective, from my understanding, it's not from the perspective of we thinking about the natural resources damage gained from the protection of the environment.
If I'm remembering right, like the pilot program kind of split environmental issues as well as state asset issues. They weren't all like exactly the same
Right,
thing.
right.
So like the
Yeah.
so the part of the administrative lawsuits were against both environmental pollution and state assets, but
Yeah.
then
Oh,
Yeah.
so not all of these cases are environmental.
No.
I see.
Yeah,
Okay.
because they are the procurators can bring cases not only limited to environmental public interest litigation. They can also bring cases related to, as for example, food safety, and against agencies, governmental agencies who's been abusing their power. So if they abuse their power, there might be a consequence of state loss, state asset loss. For example, they just gave a mine to a private person, but because they kind of like charged so that the mine got saved, that's counted as a state asset. So it's different from the environmental. Yeah.
And I'm sorry because I came in late. So the topics are broad, so it can be environmental pollution, for example, that can be brought to these courts.
You mean by NGOs or the
Oh, I'm
procurator?
sorry,
By NGOs, yes.
Sorry, what is SOE?
Oh, state-owned enterprise. I'm sorry. Yeah, that's a concept in China because some key factors, as the Chinese government says, the key factors, for example, state greed. So it's a state-owned enterprise, or like previously the train company or mining companies, some major mining companies or water companies. So these are or internet companies. They are state-owned enterprise because their majority share belongs to Chinese to the nation. So.
And of the 934 lawsuits, or just of whatever number the total is, however we want to count, about what proportion you'd say are environmental cases? A third, a half?
I don't have the number for that yet. Yeah, I'm sorry, but I don't have a number for that for now. But I can check with that. Sure. Because later, I'll talk about this later. The SPC, when the SPC was issuing some typical cases that happened on March 2017, that's last year. So they have actually, if I have a data, they're saying like the SPC, the Supreme People's Court, reported that since the promulgation of the new environmental protection law, Chinese courts at all levels has accepted 189 environmental public interest litigation cases. So, but that's only from 2015 to 2017. I don't have the most recent number. Yeah. So, and so I'm sure that because the procuratorate, they are handling more varieties of cases related to public interest litigation, PEL rather than EPO. like environmental public interest litigation or public interest litigation. So they're dealing with public interest litigation, which is not only related to environmental. So, and then in June 2017, remember, like from 2015 to 2017, these are 2 years for the pilot projects to test this system, meaning the public interest litigation brought by procuratorate. After the test, in June 2017, the China's People's Congress has made amendment to 2 very important laws. One is civil procedure law, the other is administrative procedure law. So they added 2 provisions into these laws. The first amendment to the civil procedure law actually affirms that the procuratorate may file civil lawsuits against acts that compromise public interest. So they affirmed the pilot project. The procuratorate now have the standing to file civil suits to bring civil public interest litigation cases. As you can see from that, in cases related to environmental and natural resources protection and food and drug safety. So that's one part of their public interest litigation categories. And the second is the amendment to the administrative procedure law. So in this amendment, it allows the procuratorate to file administrative lawsuits for abuse of power or nonfeasance in cases concerning environmental and natural resource protection, food and drug safety, preservation of state assets. So this is another category, and the transfer of state-owned land use rights. So this is another loss of state assets as well. So they kind of like just use a very low price to sell the land to some other people. As I mentioned just now, I said the NGOs is at the beginning of testing the ecosystem in China. It's very hard for NGOs to establish, especially when they are trying to bring cases against the local government or against the government, because that's kind of like challenging the government authority. And now the procuratorate, they are the ones who has the power to challenge the duties or abuse of power for the Chinese government agencies. So with this change, another big change on the NGOs part is that now NGOs cannot bring lawsuits against the Chinese government. So only the procuratorate can bring lawsuits to bring the administrative lawsuits. So it's kind of like exclude the NGOs from bringing lawsuits against the Chinese government. So now Chinese NGOs can only bring civil environmental public interest litigation cases. After the promulgation of the 2 amendments, very recently, in March 2nd, 2018, the Supreme People's Procuratorate, SPP, and SPC, the Supreme People's Court, they jointly issued an interpretation on the application of law in procuratorial PEL cases, like public interest litigation cases, not strictly related to strictly confined to environmental public interest litigation. So the issuance of this interpretation actually answers some questions like why and how the procuratorate got a standing, and some procedure questions as well. I would like to just bring the note here, on the latter part, to bring into because for the procuratorate, there are the amendments actually set 2 very important, we call it a pre-trial procedure for procuratorate to bring public interest litigations. For the civil public interest litigation cases, for civil cases, only if there's no authority or NGOs file the lawsuits, or if the NGO does not file a lawsuit, the procurators can file a civil lawsuit. So they have to, the procurators is not the first one to step into the play. They have to wait until, like, if there's no one bring the civil lawsuits for example, to sue the company's pollution action, or if the organization doesn't have standing and no one actually filed the suits, can the procurators bring the civil PIL?
Is there a time limit on that? Or how do you know that?
Yeah, that's one thing. I don't think there's time limit for their. So they can. On the other hand, the NGOs who met the two requirements, who have the standing, are actually very few. The number of NGOs who met it are very few. So, for example, one thing that we encountered when talking with the NGOs is like, for example, in a province or a municipal level, for this city, there's no NGO actually got legally registered. So in that case, because people are asking whether it's possible, like the NGOs and the procurators really, both of them want to bring one lawsuit. But actually what happens is that very few cities actually have a legally registered NGO who have the standing to bring the lawsuit. That's one thing. And secondly, if the case that, like, the NGO knows the procuratorate wants to bring this suit, I'm sure the NGO will not bring the suits, because it's from the resource-wise, from the budget-wise, the procuratorate, they are actually have more resources and financial-wise to deal with the cases. So although this is a pre-trial procedure before the NGO to step in, but there's no like time limit for them to give a notice or something. Yeah.
So for environmental cases, is there a statute of limitation that would actually kind of, you have then a window of time to file?
Yeah, I think there's statutes of limitation for environmental cases. I can't remember the exact time yet, but we do have a statute of limitation for bringing the case. And for administrative public interest litigation cases, prosecutors need to first offer procuratorial recommendations to the administrative authority to urge it to perform functions. So this is a required pretrial procedure. Before they bring the lawsuits against the local government, they need to first offer procuratorial recommendations. Only if when the government fails to perform, can the procurators to bring the public interest litigation cases. So this is another, yeah.
Can you just give a quick example, like an environmental example where the government has failed to perform?
Sure. For example, if they issue, if one company was kind of like, for example, if a mining company conducting illegal mine in a certain field for a long time, and the local environmental protection bureaus, the local EPBs, fail to correct or giving fines or giving any notice or correct the company's action, it can be taken as non-feasance of their duties. So the prosecutors or procurators can issue procuratorial recommendations saying like, they are violating the law, you guys, you should go and correct them. Only when the local EPB might say, oh, we've already corrected them, or they're just saying like, we think they're legal. And then at that time, if the procurators still think like the company violates the law, they can sue. They can if there's no NGOs bring lawsuits against the company, they can sue the company. And on the other hand, they can also sue the local EPB because they failed to perform their duty.
Is there, and just to follow up on that, sorry, is there some sort of guidance on that? Is there, like, I guess kind of with each of, is there time windows on which to show that at some point inaction means to bring to court or during certain?
There are maybe there are specific time windows for local EPBs to act, but there's, as I just mentioned, there's no time window for the procurators to decide like when should I come into play, or how long should I wait before I got any feedbacks from NGOs decision that they are not going to perform. Yeah.
How would procurators learn about the cases? Would citizens come to them and like complain about something, or would they go out and do?
They have the system, like they depend on the reporting from citizens, one, and sometimes the reporting from organizations who doesn't have the standing to bring environmental public interest litigation cases. So, and hotline maybe. So these are the sources.
Sorry, and just to jump on this point, there's no publicly available information that people can ask for say a corporation that's working in a specific area.
There are public available information. Like when we are in cooperation, when we are doing some cases together, or providing some support for FON, every week we will do a case strategy meeting. So in that meeting, like several investigators will just looking at the map of the, like seeing the data, sometimes seeing like this company has been over polluting or over discharging for the past 2 months, but their violation has not been corrected. And then if they see this happening like all the time, they would go and do investigations. So there are access of public available information. However, sometimes maybe the data is not like a full data, and depends on different provinces and the places. The coverage, the range of coverage might not be that full, in detail. Yeah, but there are some information available for the public.
Not to get too much into the weeds here, but so the investigators for the procurators, do they have like specialized investigators? So say someone was polluting and doing some malfeasance in the environmental field, do they have specialized environmental investigator that would be able to bring them the specific like scientific knowledge that they would need to prosecute the case, or are they just general investigators?
Not that I know of. They have like specialized investigators go and doing that, but they will, if they decided to bring a lawsuit, they will. I'm sure they will hire some. There are like expert witness, what they call. So they will have the experts to assess the, for example, the loss or the damages caused. Yeah. But I don't think now they have a specialized investigator specifically going all around and to see the polluting cases. Okay. Yeah, I should go. What's the time now? Okay. Maybe I'll just go to one typical case. I was going to bring 2 cases, but because of the timing. So one case, in China, like the law is now amended, so the laws are there, and then there's judicial interpretation. So there is some details have been interpreted by the highest court or by the Supreme Court procuratorate on how they're going to implement the law. And then sometimes after a while, because there's a new system, the Supreme People's Court and will release typical cases as a demonstration of how the new system will work. I would like to bring first the Nanping case first. So this case is China's first EPO case. As people say, this is a milestone case, as important as the U.S. Sierra Club versus Martin. So the milestone case, this is the first environmental public interest litigation cases. Actually, the two NGOs who brought this case are actually, both of them are our partners in China. So one of one of them is Friends of Nature, the other is Fujian Green Home. Both are NGOs. So it's the court actually accepted the case on January the 1st, 2015. It's exactly the date when the new environmental protection law got into effect, and what is the NGOs have the standing. So this is the first case.
It's Sunday or Saturday.
Yeah.
Want to time it.
So yeah, but the court actually accepted the case exactly on that effective date. Because the case was filed on December 2014, but the court actually waited until the law just got effective and accepts the case. I think one most important thing for this case to demonstrate is that the court actually acknowledged the standing issue for the NGOs to bring EPO cases. This is like a milestone for Chinese NGOs. And this is a case about illegal mining. So it's related to the restoration of environment and the loss of the resource destruction. But finally, so the two NGOs won in this case, and the court awarded helped the defendants to restore the damaged site, to replanting trees, also including cleaning up the waste. And if they fail to do so within 1 year, they have to pay like 1.1 million RMB. It's around 0.18 million US dollars to a special account, specially designated to do the reconstruction work if they failed to do the restoration within a time period. And also the defendants have to pay 1.27 million yuan. That's about $0.2 million as ecological interim losses to the special fund that they're going to establish, which will be used only for the restoration projects. And also the last one, which is also very important, is that the court awarded the defendants to pay the attorney fee. So this is a big case for the EPO system. But this is not another case that, and also, but after this case, we thought like there will be a big jump of growth of cases brought by NGOs, so that we can see a constant increase of EPO cases accepted by courts brought by NGOs. However, that's not the case. So we thought, at the beginning we thought, okay, so the first year, I don't remember the exact, I think it's 179 cases accepted by the courts brought by NGOs, and then we thought the second year there might be an increase. Actually, we don't see a big increase after the system has been established or developed for now two years. We don't see that big a change. And the SPC also released some typical cases just last year in March 7, 2017. One case is the one that just now my colleague was talking about, that as a Taizhou case. This case is very significant, and the reason why the SPC selected this case as a typical case, because the case actually, the media described it as awarded a sky-high award that involves issues a sky-high penalty to the polluting and to the defendants. So, I will not go too deep into this case, but you can looking at the facts and the related factors of this case through our blog. Our US Asia partnership actually have a blog, and this is one of the typical cases. Actually, we translated the facts and also the reasoning in our blog. Okay, controversies. So after the establishment of all these the amendment of the laws, issuance of judicial interpretations, there are still controversies related to this system. First off is the number of EPO cases, and NGOs finding the cases surprisingly low. So as I mentioned just now, we thought there might be a big growth, but we didn't see that. And of course, there's lack of more detailed procedural guidance. And secondly, some people would challenge this is that challenge the system is that it potentially can put double jeopardy to companies. As the example as I just mentioned, the company might face administrative penalties as well as tort-based damages for civil cases, and also for if and also they might have to pay tort damages as well as facing administrative penalties at the same time. And the third thing, which is another thing that during our talk with the judges from Chinese courts, they don't have a very clear idea about the calculation of environmental and ecological damages. So the ecological and environmental damages calculation assessment is actually one big topic that our program is working on in trying to present these courses to judges, because, for example, there's one typical case is related to air pollution. And the Chinese court actually creates the concept, they call it the virtual remediation cost. Actually, this concept is also shown in the Taizhou case just now I mentioned. Virtual remediation cost. Basically, the concept is that to calculate the damages that mostly based on the cost, that if the defendant put on a certain devices to control the pollution in accordance with the law, or has discharged the waste in accordance with law to some qualified companies, what's their cost? And then that cost might be taken as a compensation or the damages, take into consideration of the calculation of damages for environmental damages. So it's called a virtual remediation cost. In air pollution case, the company would say it's very hard to evaluate how much damages they've done, because when the wind comes, you don't see anything. And it's the same thing happened in the Taizhou case. After they dumped the acid into the river, because the river has the self-clean and the circulation function, so actually the quality of the water quality doesn't seem to after some restoration time, the water quality seems to go back to the normal level. So this is one defense that a company would say it's very hard to evaluate how much damages that we've made. But the court says even though that now the quality of the water has been come to the normal level, it doesn't mean that your ecological damage has no effects on the environment. So they create this virtual remediation cost concept to calculate the damages. But still, they are not very clear about how to calculate that, how to evaluate that, whether that's sometimes it's arbitrary, and different cases brought in different cities might result in a very different damage compensation amount. And there are other questions like unsettled management of bad damages and the restoration fund. How does the money be managed? Who will supervise the restoration? And what actions should be counted as the restoration action? Because in some cities, a very interesting answer that we got from the judge is that even if you get some money or get a compensation, you don't know how to spend the money. Like will the court be the one who supervise how to do the restoration, or the local government? And for local government, for example, the river is polluted, but the government would spend this restoration money. The easiest way is to plant trees, because that's something that people can see. And it's very hard to evaluate their restoration methods, whether that can really actually cure the damages caused by this specific case. So there are a lot of topics related to how to spend the money, who manage the money, how the fund be established, will this be supervised by a third party, and how the third party being really like independent. A lot of questions on that as well. Yeah.
Sorry, are there no remediation companies that have this like technical ability to be able to know how to clean up the site?
There are companies, but the thing is, when the court, now the system is not like very comprehensive and complicated system. So when the defendants got the ruling, even if they're willing to pay, like where does the money, who will decide to choose which company? It's unclear now. And who will decide to manage the money? It's
not put on the defendant to have accountability to clean up their site, and then they can hire.
In some cases, yes. In some cases, yes, they have the responsibility, and they can, like in the Nanping case, they have the responsibility to restore, to clean up the waste, and to plant the trees in 3 months after the issuance of the judgment. I think, yeah, of course, the company will find someone to do that, or they will not. They will just, they're not the professionals, and they might do so just based on their best judgment. So how to evaluate whether the ecological function has been restored, it's another issue that's still pending. The company might just want to save money and find someone like who doesn't have the qualification. That's
one of the issue is also the role of the EPB, the local, like the equivalent to EPA, like what was their role, and it's not entirely clear. Some of these cases, they're not even party. Some of them may be, and some of them are not even party. So once the judge issue these decisions, is it incumbent upon the plaintiff to make sure that they're doing it right, and do plaintiffs have the actual expertise to make sure they're doing it right? Or is it just incumbent upon the defendant to hire somebody, and then you accept it as like, okay.
Right. There's very little personnel or very little resources from the state to be able to evaluate.
It's not entirely clear if the EPB is actually, the local EPB is involved in this. Some of the cases they are, some of them they're not.
Yeah. I mean, who will decide which one to hire to do the restoration, there are some expert professionals and companies have information, have the capacity and the skills to do the cleaning up, though not a lot, but there are. And but I mean, like the court will not just to say like you should find this company to do this cleaning up. Probably like the local EPB should know better because they have more expertise on that. But the issue is just as Sutif mentioned, they're not the parties, and it's unclear how they can get involved in this whole process.
So it's very different from the U.S. system. Whereas the U.S. system, the EPA or the local DEP will be involved in overseeing some of this, and it's because it's enforcement of environmental laws and regulations. In these cases, it's more still kind of based on tort system. Right. It's not violation of a regulation.
By violation.
Yeah, so that's the slight difference, and they're still struggling figuring out how to handle all of this.
I mean, there are some environmental standards, and if they're violated, they're just violated until someone brings suit. There's no someone to bring it.
The local EPBs, the local EPBs can actually issue administrative orders and stuff. So
yeah.
In the administrative cases, has the EPB been the defendant? Been sued for?
Yeah. A lot of the environmental public interest litigation, the administrative cases are against the local EPP. So this is the final part. It's a very simple comparison with between China's ecosystem versus U.S. citizen suit. First off, in the U.S., as we know, like the organizations or persons who bring the citizen suits are taken as private attorney generals. And in the U.S. citizen suits, they can challenge both the polluting industry as well as the government agencies' failure to perform the duties. However, as I mentioned just now, in China, for civil EPO cases, the NGOs and the prosecutors, they can bring civil EPO cases. However, for prosecutors, they have to follow up the pre-trial procedure, meaning like waiting until there's no NGO bring up the civil cases. And for administrative EPO cases, only prosecutors have the standing to bring that against local government. And secondly, in the U.S. citizen suits, the laws who allow the citizen suits are usually strict liability laws. So a lot of the cases, in theory, the plaintiff, there's no need for the plaintiff to prove legal violation. The plaintiff only need to prove legal violation, no need to prove the environmental damages. However, versus in China, the NGO, one big challenge is that NGO is always facing is they have to prove and assess damages, which is really difficult. And a lot of them, like, it's invisible. And our NGO partners has been suffer a lot of obstacles in doing improving the damages. It's really hard for them. And thirdly, from the standing point, the NGOs in the U.S. have to show injury in fact in order to bring the case. However, in China, this is not the case.
I think the only non-lawyer in the room. What is injury in fact?
Maybe someone can help and explain. Like, yeah.
My understanding is just the injury to you personally.
Actual injury.
I'm sure.
Okay.
Yeah. So.
Broken arm.
Yeah. So at least NGO has to show like you're really harmed by this act. But in China, the NGOs does not need to show injury or harm to the NGO themselves. They can file EPO cases. For example, they are located in Beijing. They can file EPO cases against some companies in Yunnan, which is far away from Beijing, and against the polluters anywhere in China. So that's one thing different from the U.S. And that's why now, as a common practice, the local NGOs will not bring, especially before the prosecutors come into play, like when the local NGOs can still have the standing to bring cases against government agencies. So the common practice is that the Yunnan NGO will not bring a suit against the Yunnan local EPPs. So the Beijing NGO, they can like have a connection, they can talk. So the Beijing NGO will bring a suit in Yunnan against the Yunnan EPP, so that it's avoided the latter. Because in Yunnan province, people would thought, oh, this is an NGO registered in Beijing. So the courts and all the related parties will take it more seriously. So, and also to avoid the consequence that the local NGO would be, for example, if it's an environmental NGO and they are suing a environmental protection bureau, I'm sure later on they're afraid that there might be something happening to them. So that's a lot of like why our partners have a lot of trips to different cities. Finally, the remedies are different. As I listed the remedies here, and of course how the damages can be awarded by the court, how the funds received managed. That's the challenges. Whereas, as just now you mentioned, one of the students said, in the U.S. the system is more of a comprehensive one. There's some guidance. And lastly, which is really another very important factor from the practice perspective, is the attorney's fee. Because in the U.S. system, in the citizen suits, U.S. is using the reasonable appropriateness standards. So generally, the prevailing NGOs usually, like when the court seeing like the prevailing parties, the reasonable, if it's reasonable and applying the appropriateness standard, the prevailing NGOs usually got the fee. And for the prevailing defendant, meaning the industry or the governmental agency, it's only when the suit is frivolous or harassing or without merit does the court will award the attorney fee to the prevailing defendant. However, in China, one big challenge for the NGO lawyers is that the article, the civil in the civil EPO judicial interpretation, although it says it's reasonable attorney fee to the prevailing NGOs, however, there are other restraints to this provision. It says the NGOs cannot seek economic benefits through environmental public interest litigation. So in practice, it's always an issue of for the NGO lawyers, that the NGO lawyers are facing is that or the NGOs are facing is that they pay a lot of, for example, investigation fee or the expert fee or assessment fee, and later on how to evaluate that and persuade the court saying that getting these feedback is not gaining a profit. It's something, it's very sometimes very challenging for our NGO partners. Yeah. So and the Changzhou case, I think one thing the Friends of Nature is facing is that actually the court saying I think it's around 1 million attorney's fee for both parties have to be borne by the NGO, which is a big challenge for the NGO because once they lose, they don't have anything. So it's a hindrance for the NGO lawyers to rethink whether or not to bring the case to avoid such a situation. Yeah, I think that's it. And finally, is one quote from our president. Xi, as also now in China, you can see all the slogans of building up a beautiful China or to advocate ecological civilization is what we call. So more and more attention is being casted into protecting the environment, that's for sure. And a lot of reforms on environmental laws in China has been going on, a lot of change has been going on, and our professors visit there from the US has a feeling that they feel very excitement every time joining our trainings for example, judges or prosecutors, or going to for seminars with the scholars, because they can see they're actually having an impact and influence to have this whole changes happen. And the judges would ask very practical questions, saying like, how do we evaluate this kind of damages? So they can see their influence. China is embracing all these ideas and influence to protect the environment. So if you're interested, you can learn more about our programs and our good activities through our blogs. And and we're hiring research associates. So so just if you're interested, do pay some attention to our programs, activities, and our partners in China. Thank you.
And actually, I'll show you, I don't know if you pointed this out, but our Associate Director, Yan Meilin, wrote a little article on an example EPOL case in our most recent newsletter, and sort of also talked a little bit about some challenges there.
So we want to read it. Thank you.
Other questions?
Are there any other questions?
I did have one more question. With the NGOs, are those mainly the NGOs that have been challenging? Are those only Chinese NGOs, or are there outside NGOs that can fall within the law that are allowed to
I'll
challenge?
add, I was wondering, can Tibetan NGOs bring?
So now the IPO cases are only, as you see, to satisfying the two requirements. One is got registration. The second one is to have been in this environmental protection services for at least 5 years, consecutive years, without any violation of law. I don't think the government will carve out the Tibetan part as a special district, but I don't know any NGO actually registered in Tibetan. As I said, there are not that many NGOs got really registered. And for foreign NGOs now I don't see any cases from my even registered foreign NGOs. No, I don't think so. So yeah.
Yeah, you have to be registered with the
The civil
the specific
civil
department,
affairs department.
above a certain level, above municipal
municipality level
So
with
foreign
districts.
NGOs cannot register as a foreign NGO under these. We can register as a foreign NGO, but not as an NGO.
Oh, okay.
Yeah.
Okay.
Yeah, so only Chinese NGOs can bring these cases. But if there are Chinese NGOs got successfully registered in Tibetan, if they satisfy the two requirements, they can bring cases.
But there are like NRDC or Client Earth or some of those kind of NGOs that do have offices in Beijing and are registered.
Yeah.
They might help the Chinese NGOs with just sort of general information exchange or capacity building or that kind of thing, but they can't directly bring a case.
Okay. Could they help them with funding in any way? Like with the amount, like if say a Chinese NGO needed help with like the funding for a case or something like that with attorney's fees, could they help out in any way with that? Like if they felt like a certain case was really important?
In theory, yes, they can. First off, it's very hard for the foreign NGOs to register in China, but there are like a lot of foreign NGOs that actually got successfully registered. And secondly, if they got successfully registered, and I think they can provide funding help to the Chinese NGOs.
Yeah, but now the law is strict that you have to submit an annual plan. It has to be approved by your supervising unit and whoever you're going to be registered. So in the approval or review of this plan, they could say, no, not this item, not this item. Yeah, so it's a possibility, but
Yeah. Yeah. So for activities outside of their work plan, they cannot got involved in that activity. So
it has to be a work plan as approved.
yeah, and it's very hard for a foreign NGO to foresee that next year I'll involve in this case with the NGO and they reported and got approved.
But they could support the NGO working on cases, different cases, but they can't say this for case. I mean, if they provide support to them, and they can use that. And then now a lot of NGOs are actually getting a lot of domestic funding. There's a big philanthropy development in China now, so they are getting funding for that type of work too.
Yeah.
So that's cool.
I have a question that I don't know the answer to, and I don't know if you do, but I was wondering because I remember when I was in China and talking with NGOs, they talk a lot about like the cases and like damage assessment and these kind of things, but it didn't seem very often that they would talk about like, is this having a deterring effect on potential defendants? And I was wondering, and I'm not aware of any studies that have been done on that either. Have you heard of anything to that effect?
You mean the deterring impact?
Like for example, if like a company would think twice about polluting because maybe Friends of Nature or even the procuratorate might sue me down the line.
No.
Yeah.
No. Yeah. As you can tell, that this is still very new. But I think when the prosecutors now comes into play, and since their function for the previous, like the most powerful function for anti-corruption has been taken away, I think they might cast more attention into the environmental or the public interest litigation cases. If that sector comes into play, probably at least the company would think twice if they got too much, like before they do too much of the polluting action or the illegal polluting action. That's my thinking. But no, but I don't have an answer for that as well. But I mean the case strategy meeting that I got involved in, I think when the NGOs are choosing which case to bring, they do take into consideration of the deterring facts. Meaning like they will of course choose some cases that have the biggest impact, and have some values to demonstrate the implementation, and also of course most likely they will prevail because this is still like the testing stage. They would like to setting up examples as well, and even for the Supreme People's Court's typical cases, the courts will also say like there's one big point in the in the case is saying like even though the water quality got back to the normal level, it doesn't mean that you don't have any harm done to the water. I think this is a kind of like explanation and a good demonstration of the duties of the duties from the company's side that you should pay attention to when you're doing the discharging. It's not like you can, so they will choose some typical cases, and the NGOs will think whether the case they bring up will have a better impact for the deterrent.
I think right now they're probably at a level where they're focusing more on cleanup and addressing some of the key and pollution issues, and not necessarily thinking about deterrence yet. They haven't gotten to that stage. It's about cleanup, making sure some of these pollutions are being kept up. Or some funds set up to address some of these issues.
Two questions. One about cleanup. You said that the courts are struggling with standards, and is the equivalent of EPA in China working on a guidance, or the ones that have been used, like you said, the virtual remediation cost, is that based on what kind of pollution control technology? Fast available, affordable? Who decided in the cases that were ruled?
So the first question, I do think the MEP is working on trying to set some standards, as we are in discussion, for example, with the Chinese Academy of Environmental Planning. So they are the kind of like the academy whose their expertise are in the damage assessment and the restoration of ecological function of the environment. So they are now, and the judges also invited the experts from that academy to give lectures to them for the trainings as well. I think they do working on something to at least either, for example, they've already built up an experts database in China who can do the evaluation of the damages, and they are obviously learning from other countries' experience in how to do the evaluation and learning from the different models. I think this is something that because this academy is under the Ministry of Environmental Protection, MEP, so I do think they're working on the evaluation. And the second question, when for the virtual remediation cost, the judges were calculating that based on the fact, for example, in the case that I was going to talk about, they hired someone who doesn't have the qualification to deal with the acid byproduct to kind of like discharge the byproduct to the acid byproduct at a very low price. So the courts, when they are calculating the virtual damages, what they call, is that they're saying if you hire someone who is qualified, who has a qualification or certification to handle these acid byproducts, what's the cost for that? I mean, per ton or, and then they calculate the differences, but there's no concept such as the US, the best available technology. There might be prices difference for different qualified agencies as well, but the court was just seeing that compared with the illegal discharging and calculating the differences and then calculating the damages based on this. But I'm sure, like, I think, yeah, there should be a standard in evaluating the damages. It's just now we still don't have that yet.
Has there been a survey of the equal cases and looking at the cases that are won, what kind of defendants? Because among polluters, there are big companies and then there are little people who may lose the case more easily. Do you see a pattern in the defendants, or is it a variety of big companies being sued?
My take on it is I've noticed, like, I think Friends of Nature, that NGO is the one that really tracks it the most. I don't know, maybe others do too, but like I've noticed with their reports that it's a lot more state-owned enterprises are becoming defendants, but I don't know the proportion. Maybe I think the first year it was all very small polluters, and then the second and third years, like they got a bit braver. Like,
And for state-owned enterprises, for example, they sue in the electricity companies or the dam, the construction companies for dams. I think another thing that they think this is like, on the one hand, yes, they are more brave, they are more experienced to bring these cases, and on the other hand, I think these are cases that have a better deterrence influence or impact, because like these are state-owned enterprises and we can even challenge them, let alone the private companies. So yeah, I agree with Doc. Yeah, now they are challenging, so they're challenging the more state-owned
What
enterprise.
about multinational companies? Are they being sued?
there was a case where, wasn't it, the Green Development Fund sued ConocoPhillips over the oil spill?
Oh,
And Volkswagen too. They brought a case against Volkswagen for emission data,
right.
I think. I don't know if either of those cases went to trial though.
And if that, yeah, I'm not so well aware of those two cases, but if that's the case, yeah.
It's developing.
Yeah, it's developing. Okay, thank you very much. Thank you.